Again, hi everyone, good afternoon. My name is Cecilia Ricab. I am an associate professor in economics and also the head of research here at the Institute for Innovation and Public Purpose of UCL. And today we will be having what I'm sure will be a very interesting debate on mass data surveillance and predictive policing. This debate is actually a book talk. We will have the author, Plixavra Poglatsoglu. I tried my best with just her name, and that will present the book, and then we will listen to Matt Cole, much simpler surname, here on my left, that will discuss the book and also ask some questions, and then we will open it to all of you for Q&A. But before we get into the book presentation, let me just say that here at IIPP, we've been hosting a book talk series for over a year and a half already, and this series is particularly aimed at showcasing young scholars that have the courage and the sufficient interest to engage in challenging, bold questions and doing it by writing books, which normally is not so rewarded in the academic career these days. So it's for us a way to also promote the idea that we need to engage in these challenging topical questions with sufficient depth, and that papers are usually not enough to do it. As part of this series, today we will have Plixavra, but you can also watch the previous discussions that are all on IIPP website. This will be the last discussion of this term, however, in terms of book presentations. However, IIPP has a lot of other events planned for this term, including on May 8th, a debate on digital sovereignty and the role of the state and how to think about digital sovereignty today. That debate will have the two of us again sitting here, along with 7 other colleagues. It will be a wide and open debate on these topics. And I think that there couldn't be a better way to introduce part of the challenges regarding the question of digital sovereignty than actually discussing about mass surveillance and the role of the police, but also discussing about the role of private companies in mass surveillance and the interplay between corporate and political powers in this question. So without any further ado, I give you the floor, Plixavra. Thanks a lot for being here.
Thank you very much for the kind invitation. It's great to be here, and thank you for taking the time with my book. And I will definitely attend the talk on digital sovereignty, which is the focus of my current research. But for today, I will be focusing on presenting my book. Okay, to set the scene, my book is focusing on mass data surveillance for predictive policing purposes. And where is the focus of my research? It's basically what we have been identifying, and many people before me have been identifying, is that there has been a shift in the focus of security, and security trends focusing more and more on trying to forestall threats before they can even manifest, instead of reactively acting after a threat or a crime has already taken place. And while that might not look like the Minority Report, what it might look like now today is, for instance, every time we take a plane, the data we give to airlines in order to book our flight are being transferred to a specialized security authority, which processes this data in order to find, it processes the data against predetermined criteria in order to find individuals that could likely pose a threat and could be deemed as linked to a criminal activity. So this is what is discussed as, or I examine as, mass data surveillance for predictive policing. And for this to happen, and I focus a bit more on the EU setting, but this is more of a global phenomenon, there's a lot of elements that come together. First, as mentioned, the private sector. With increased digitization over the past years, vast amounts of data are being accumulated in the hands of companies. And of course, security authorities want to have access to the data. So when security authorities ask for data to be processed en masse, and when there are laws that impose that processing en masse, that can be described as untargeted data processing and thereby mass data surveillance. In order to make sense of the mass amounts of data, At the same time, we have also seen the surge of intrusive technologies defined as predictive policing technologies that basically make statistical predictions and try to identify within mass amounts of data patterns that could exhibit patterns of criminal behavior that could show whether an individual could be deemed as potentially threatening. And through those patterns, they can guide security authorities towards those people who should be subject to more surveillance if they're deemed to be threatening. Finally, in the EU setting, we should also consider how the EU has brought security powers that enables it to adopt such legislation of mass surveillance. And specifically, what I have been focusing on are 3 private sectors where the EU has adopted such measures, and that is air traveling, as I mentioned earlier, but also electronic communication services and finance sector. And here is worth also mentioning that the powers of the EU to do so are broad in the sense that can be linked to, for example, facilitating the cooperation between police authorities, but also as broad and vague as ensuring the harmonized and effective functioning of the internal market. So the reason why I focus on these instruments is that even though they can function both for after a crime has been committed and for preventive purposes, what we see in preceding policy documents is that these instruments were very much motivated by this pre-crime rationale. And they, in this focus towards the preventiveness, they pose distinct risks to fundamental rights and have some distinct characteristics from traditional reactive security methods. So what I was basically investigating in the book, which is based on my doctoral research, is can, and if so, under what conditions are these legal instruments of mass data surveillance lawfully established, taking the lens of the EU's powers to provide security based on its competences and also the legitimization of security as an objective, and on the other hand, through the lens of the EU's obligation to ensure respect for fundamental rights. And there I looked into specifically 5 fundamental rights, namely privacy, data protection, effective remedy, fair trial, and presumption of innocence. So the rest of the book after this introduction, and this is how the rest of the presentation is also somewhat structured, is looking first at the EU powers and the deriving instruments. I then look into this objective of security, how it's been transformed into this pre-crime rationale and the predictive policing technologies that come along with it. I move on to go into an in-depth investigation of what does this intersection between mass surveillance and predictive policing has on fundamental rights. Finally, I examine how the judiciary have reacted to these instruments and practices, and I make a final synthesis where I point to some gaps and recommendations. So, as I mentioned, the EU has broad powers to adopt security measures, but those measures should respect the objective for which they are adopted, and that means that they should be proportionate and correspond to the underpinning objective and specific legal basis. Also, while the EU does not have dedicated and broad competencies to adopt legislation in order to promote specific fundamental rights, besides limited exceptions like the right to data protection, where we have the GDPR, for example. In general, the EU must respect fundamental rights as part of its foundational values, and therefore security measures must also respect that. The measures that I look into, while they have some differences in how they apply in the private sector that they involve and the legal basis that they have, that they rely on, they do share a lot of characteristics, and this is why I kind of investigate them under a common cluster. Most importantly, they impose the same or similar obligation upon the private companies to be involved in surveillance by either directly transferring personal data to security authorities or retaining and processing the data themselves for security purposes. The aim is the same. They are measures that have been, as mentioned, motivated by a largely preventive and anticipatory rationale. These are measures that were very much brought into the fore after post 9/11, and therefore they are meant to fight serious crime and terrorism. And while there can be both reactive and preventive measures, the preventiveness is also evident in how they either directly foresee or indirectly allow for predictive policing techniques to be implemented. So here it is also, of course, important to note that there was a new legislation that actually entered into force or was adopted after my research was done and while I was finishing drafting the book or revising the book, and that is the AI Act. And the AI Act provides for a prohibition of predictive policing, but on a closer look, one can see that this prohibition is very limited. It only prohibits a predictive policing that is solely based on profiling, which was already the case with data protection legislation. And it does not apply this prohibition to systems that are used to support human assessment. And in a security context, there are no AI systems that would ever be used without any human assessment. So that is quite obsolete in a sense. So basically, most predictive policing systems are considered high risk, and that means that they have to follow a lot of requirements that have to do with transparency, with documentation, with accurate and robust and cybersecurity requirements. However, this set of requirements and the AI Act is mostly an internal market instrument, and as such, it did not really affect my investigation of more fundamental questions around the intersection of mass surveillance and predictive policing. So focusing now on the security objective and this pre-crime rationale, and to clarify what is the shift that I mentioned in the beginning, basically I started looking into more traditional theories and understanding around security as a legitimizing objective. And in most common theories and the Western liberal understanding of how the state is created, think of the social contract, for example, the citizens give away part of their liberties to the governing body for that body to protect them from harm. That is how we traditionally understood the creation of the state, having as a very important function to provide security to its citizens. However, when we see the shift that is been undergoing now towards the pre-crime era, then there are several differences with initial understandings of security. And I will not go into everything, and it also goes beyond the scope of my expertise, but what the main points are, first of all, there is a focus on trying to reconceive crime as a patternable and measurable phenomenon that is no longer so much about the causes and causalities of crime, the socioeconomic drivers of criminality, but it's more about identifying patterns of criminal behavior by considering the criminals as rational actors that repeat the same behavior, and therefore they can be identified. And to be able to do that, we need more surveillance and more technology. And to be able to deploy more surveillance and more technology, we have a lot of different public and private actors that are working increasingly together, collaborating, which also means that the lines between the different public and private authorities become more blurred, and the accountability of who is subject to what rules and what are their obligations become also more blurred. Furthermore, where in traditional understandings of security, the idea is that we prevent someone's liberties to protect a specific harm. For example, putting a criminal in jail to punish them and deter others from perpetrating the same crime. in the context of mass surveillance and predictive policing, we have a lot of people being subject to those measures without any direct link to this potential future harm. And in this way, these measures and this intersection of mass surveillance and predictive policing carries a lot of risks, whether that is because the risks are inherent to the technology itself or because it is the combination of the two. It is well known that algorithmic decision-making is opaque, it's complex, it's difficult to contest and understand. And there, maybe the AI Act will mitigate some of those risks. It is often reported how these measures lead to a lot of inaccurate results. There is a high number of false positives, for example, which means that people are falsely identified as guilty or threatening. There also, predictive policing technologies are widely reported to be biased against specific groups of people and societal groups. The accumulation of data in the hands of select actors also reinforce the informational and power asymmetries, and in that way there is a heightened risk of an arbitrary use of this power. That can further diminish the potential sense of trust towards the governing bodies. It can cause a chilling effect towards the citizens to exercise and prevent them from exercising the right to participate in activities. These measures are also potentially carry the risk of being more expanded. As I mentioned, these started as measures as a reaction to terrorist acts, but now they are measures for a broad range of serious crimes that are further defined in national laws, and in that way they could be applied quite broadly. And finally, as I mentioned, there is a lot of different actors involved and a lot of different instruments that regulate these practices, and therefore there's also a lot of uncertainty as to what applies when. And these risks can have an impact on the individual, the person, for example, who is falsely found to be threatening. It can have an impact on collectives, the groups that are oftentimes more likely to be subject to surveillance or be pointed out and identified through these technologies. That further has an impact on society at large when there is a chilling effect towards individuals and citizens from participating to the democratic, to political activities, for example. And ultimately, while these measures and technologies are always looked in isolation, they of course can have a cumulative effect. They shouldn't be taken into account. The legislator often only assesses the e-privacy directive, for example, or the PNR directive, but not all the mass data surveillance instruments that are in place at the same time. So then, taking all these risks into account, I look into specific human rights, as I mentioned. First, with regards to the right to privacy, oftentimes we think of privacy as more of a right that is individualistic. It's because it's focusing around the intimacy and self-determination of an individual, but it also has a very important role to play in enabling people to participate in society. And therefore, as mentioned, these risks can have a severe impact. The right to personal data protection is a younger right, is often considered as the digital mirror of privacy. However, it also has a different scope and could be considered more broadly than it currently is under the current legislation and case law. It is supposed or is meant to provide control over one's own data, but it also allows through, for example, secondary legislation to collectively enforce this right. And it is meant to be an instrumental right to safeguard all other fundamental rights. And in that way, it should be able to play a broad role by empowering people against information asymmetries. I then looked into so-called justice rights because they are often considered important when we're talking about predictive policing, especially the presumption of innocence is often, for example, the parliament put forth a prohibition for predictive policing because of its potential impact on the presumption of innocence. However, when I took a closer look at these rights, and especially fair trial and presumption of innocence, I saw that the way that it is currently constructed, or our current legal framework, the way that it allows exercise of these rights, it very much depends on having a criminal charge. It is a system that is created for reactive purposes, for providing for the fairness of proceedings, for the contestability of evidence, to protect innocence from wrongful conviction, but it's not meant to protect somebody who has not yet committed any crimes. The people identified through predictive policing technologies would never come close to a criminal, are likely to not come close to a criminal procedure as such. So there's a lot of surveillance that can happen, for example, in a stage that is before the applicability of these rights. So with all this in mind, the Judiciary has a long list of cases where they look into secret surveillance, mass surveillance, and algorithmic decision-making by criminal justice security authorities, and that are looked at both the Court of Justice and the European Court of Human Rights. And they have provided for several safeguards where basically the more important the security goal is, the more broad the surveillance can be. So if we're talking about national security, then you can have mass surveillance. But the way that the courts have provided for these specific conditions, ultimately they also have, for example, given the Court of Justice has stated that you can have targeted surveillance when there are objective criteria, for example, on the basis of a selected geographical area. And that can mean a whole neighborhood, and all the people within a neighborhood could be subject to surveillance. So then when we're talking about targeted, it can still be very, very broad. So there has been a lot of criticism also against this case law, first and foremost because it legitimizes mass surveillance by providing for these conditions. And then because these cases often neglect this risk of expansiveness I mentioned earlier, how this pre-crime rationale, and when these measures are really meant to be deployed for preventive reasons, they should be considered distinctly from the post-crime reasons. And also these cases do not consider collective, societal, and cumulative impacts. So my conclusion has been that I identified several gaps. First, by finding that these measures, there is often a disconnect between the legal basis, the specificities of the measure, and the underlying policy and preventive rationale. The normative underpinning is currently contested, if not missing, given that traditional security theories are not really deemed to be fit for the purpose of pre-crime. A lot of fundamental rights aspects and safeguards are either missing or being neglected, and the regulation that is applicable is quite fragmented. So, to counter this or to try to mitigate this, my recommendation were that first and foremost, if these measures are to be applicable, there should be a more examination as to its normative underpinning, and while that would require a more interdisciplinary understanding of crime, criminality, and pre-crime, from a legal perspective, there should be at least a grounding on human rights. The effectiveness of these measures should be demonstrable, and where it cannot be demonstrated, then we should consider what that means. In adopting these measures, societal and cumulative effects should be considered, and the collective exercise of rights to protect groups should be enabled. the right to personal data protection and should be able to play a broader role in the sense of more collective exercise, for example. Justice rights should be adapted to this pre-crime era. And finally, where strict conditions cannot be met, these practices, in my view, should be fully objected to. So this was my presentation.
Thanks a lot. It was super clear on top of being super interesting. And I think that at least for me that I'm not a lawyer, that was very much appreciated. I will give the floor to Matt for his comments and questions, and then you will have some time for replying or expanding on what you have presented.
Yeah, thank you very much for the opportunity to educate myself on secondary law and case law. I too am not a legal scholar, but I think really understanding the Data Protection Directive, Retention Directive, Data Protection Law Enforcement Directive, GDPR, all of these sorts of, how these legal infrastructures enable the technological infrastructures of our current era is really important. I wanted to, I guess, highlight a couple. I mean, I have a kind of 3 sections of, I guess, exploring my thoughts on this book, and I guess they all kind of revolve around this term used, normative underpinning. So I'm kind of like going to talk a little bit about some of the philosophical foundations of both the book, but also the EU law, Millian and Kantian foundations, which I thought that was an interesting and important entry point. We're not going to do metaphysics of morals, but we might do a bit of moralizing. And also, my area is around technological change and political economy of work, and how specifically around like wage theft and unpaid labor. So I was kind of thinking about harm, about these protections, and in the book they're mainly oriented around like private citizens and oriented around individuals and not towards organizations. But I was trying to also think maybe we can think about organizations as actors here as well, and it might flip some of the, I guess, protection of data protection on its head when you think about democratic accountability of organizations. So I guess what the book is sort of oriented around or based on is the criminal law's harm principle, right? Which you say doesn't actually help in understanding the link between the preventative part of the measures and the harm these measures seek to prevent, but that's nonetheless the sort of entry point for this like normative underpinning of the law. Specifically, John Stuart Mill's principle of harm, which concerns the exercise of any political or social power or coercion, not necessarily or only criminalization, but regulation at large. And I guess his sort of, he holds that coercive power is exercised, is only rightfully exercised over an individual to prevent harm to others. But as you point out in the book, and anyone who's critically minded might observe that what constitutes harm is the question here, and we can debate this in a lot of different ways. Mill doesn't offer a precise definition. Trying to get to a precise definition is part of the journey of the book, and you problematize it, right? If I'm reading you correctly. And specifically thinking about pre-crime harm and the kind of mass collection of data as well, you can sort of see the trajectory, I guess, into the future if you're a security firm or you're a kind of AI-pilled police chief. If you look at generative AI and you can see the probabilistic large language models and neural nets, this learns language through patterns, and you can learn crime through patterns, and that was the sort of seems to be the trajectory here, but that we're trying to maybe prevent, because obviously whether an AI can write a poem or not there's a bit less at stake there than whether or not AI can lock you up for terrorism, right? So this is this kind of preventive approach is obviously, I think, harmful in it of itself, and you go in and talk about how you might have 500,000 false positives, right? But it also makes me think about how would you fight back against this, or how would you ensure, how would you use the law against this kind of overreach of policing, or an AI police state, right? And I think when you talk about that element, you get into the Kantian idea about instrumentalization. So individuals should be enabled to uphold their own dignity. You shouldn't be using people as means, and they should be an end in themselves, right? But there's also this other principle of autonomy, and autonomy as one definition of freedom, in which but autonomy can't be understood only at an individual or a private citizen, as a private citizen, but has to be understood in social terms. So ensuring the opportunity to fully function in all aspects of society, and freedom lies at the core of this autonomy, right? So these are kind of some of the normative underpinnings of the EU fundamental rights framework, but my understanding of these ideas is I think much more radical than perhaps the EU's, and also probably a bit more radical than the enforcement of the law, because I don't see it. I was reading this thinking about, okay, how would you use this preventative measure, or to prevent harm, if we were thinking about all of the private companies that are out there doing environmental damage, which has social impacts and prevents freedom and autonomy to people and ruins their lives and so on. Also rogue employers who start, use cascading subcontracts, or use the law against workers in terms of like self-employment or gig economy work, and then figure out algorithmic ways to shave time off, right, and engage in wage theft. So I was trying to think about how maybe the Charter of Fundamental Rights of the EU or the ECHR Article 8, how maybe we could think about these in terms of wage theft and employment protections, and if that would even work in the context of the framework outlined in this book. And so might attempt a little bit of that here. So in terms of the Kantian principle against subjective of human beings, this in terms of mass data surveillance, I was immediately thought about function creep, which you mentioned in the book, right? And that obviously treats individuals as a mere means rather than an ends, because most of the time the data is collected in a very speculative manner. Even though in the GDPR you have to specify it's for this and it's for this, and the data controller has, accountability over that, and it has to be for a certain period. Many companies just completely ignore this, right? Especially American ones. And so then it comes down to what kind of enforcement mechanisms you have. But I think function creep is probably one of the biggest risks for both private citizens as well as social groups and groups of workers. Data exhaust or triangulated data that's not directly related to any one thing can be repurposed for cost saving or targeted pay cuts, discriminatory profiling that harms certain groups of workers. Even though we have all the EU employment laws that are supposed to protect against this, the enforcement of those laws is really a question of the power of the combatants, right? And as we've seen, labor share of income and labor protections both erode that balance of power tends to shift in favor of the global tech monopolists and their state agents, which I'm sure Celia can speak more to later. So then, thinking about the harm principle and Mill, if we were kind of to turn this on to employers, employers would need to show that surveillance or algorithmic systems are like strictly necessary just to avert actual injuries. So maybe going back to like the more traditional occupational health and safety laws, which are actually kind of fairly strong in the UK context, but they're applied less so, I think, in terms of digital rights and protections, maybe in certain parts of the EU. But we can also think about an expanded notion of autonomy in relation to these principles about how greater data protection could be used to enhance workers' ability to organize, negotiate, or collectively challenge employer violations if those employers were treated as potential criminals, right? So these patterns, this mass data collection and pattern recognition, even though we're framing it largely as a problem and as a big brother state, if it were directed more against capital and financial crime, which I know there are parts of the book where you do discuss that, but I'm thinking more in terms of patterns of employment violation, potentially, that we could repurpose it, right? And there are lots of potential areas in which mass surveillance could actually, in that way, enhance fundamental rights. Perhaps, maybe you disagree, but I would like to maybe put that more as a question. I didn't actually write questions, sorry, but these are lots of points that you could raise or tell me I'm completely wrong or just like riffing. Where am I on time? So then it got me thinking about the AI Act, right? Because it makes an appearance in the book, but obviously this is stuff that's moving quite quickly, much quicker than publishers do, and yeah, that made me kind of try to look up what the relevance of the AI Act to some of these mass data policing, the charter, and how potentially the gaps are similar maybe in the AI Act as they are in some of the GDPR and the DPL. Yeah, the Enforcement Directive, yes. But I didn't actually get that far into it other than looking at Article 57, which defines, it looks at the application of AI to employment. And it was interesting because basically any use of AI systems in any integral way, in any official way, is, at least in that definition, seems as like they qualify as high risk. And then if they have high risk, there's a whole series of quite robust like checks and balances that are going on. But then again, the question of enforcement, and is this left, who's enforcing this, right? Because the police, they don't really enforce employment law unless it has to do with migrants and they want to arrest and deport people, right? So maybe you could actually, if you could maybe speak a bit more about some of the application or non-application of the data protection to EU labor protections and the sort of pillar of social rights. There was another point I wanted to discuss around groups, right? So data protection of groups, which is much different than private individuals and possibly a better framing, I think, right, in the book, or there are different implications at least. Because looking at individuals as isolated datums isn't really the way that AI or tech looks at them, right? Because my data means nothing and is valued at nothing unless it's in relation to your data and everyone else's data, right? It's I can't remember there's a term for the size of a network corresponds to its value, right? So the way that these predictive policing tools, as well as any other kind of AI, it doesn't view people as private individuals. It views them as groups. And so if we're looking about how to protect people, we also need to operate on that level. And if we're thinking about employment, or we're thinking about social programs, or any kinds of areas of like thinking about how to protect people, the first way of doing that has largely been about like thinking about intellectual property, and like don't click yes when GDPR and asks if you want to share your data. But again, that's isolated individual data, not group data. And I was wondering, what could we do to think about how to protect group data using the existing tools that we have, but also trying to move past this individual intellectual property or individualized personal data. And so those are my general kind of reflections and points. A bit all over the place, but hopefully interesting discussion.
Very much. Thanks a lot for the comments. I will start with the middle part, perhaps, the idea of flipping mass surveillance. I think that is a very nice and interesting suggestion, because I have been worried about expanding towards other crimes or petty theft, or that is usually how the concern is framed, that we will move from terrorism to any sort of serious crime to petty theft, for instance. But trying to flip it towards using it for that broader social good, or these social values that I also look into the book, it could be a very nice proposition. Because that is the thing that I also was very baffled with when we talk about harm. We only think about the crime or those very specific crimes that security authorities build the whole agenda, or that states build their agenda around. And we do not look at the broader harms of society. And while you have a few exceptions of judges here and there making these points and raising the point of we're turning into a surveillance society and we're not really getting anywhere with these tools, so what are these tools for ultimately? I think it would be very important to include in this conversation the actual harms, like the environmental harms that are happening now. And there has been, from a very different route, the right to privacy has been used for environmental cases under the European Court of Human Rights. It was a recent case from Switzerland, I think. I know little about it, but there have been some attempts, and there are some civil society organizations or youth organizations that do try to make this claim that our lives are being hampered through all this big tech or other organization destroying the climate. So I can certainly see how all these values and there is a lot of discussion of the EU around values. Unfortunately, sometimes it falls a little bit flat, and the political will behind this is such that it doesn't open the room to giving more substantiation around it. So for example, when we're talking about AI and the AI Act, sustainability, data centers, how AI is being produced and on what resources it relies, there's almost nothing on the AI Act. And then also the bigger issue here is that the EU has this approach of regulating externally to protect its citizens, but does not consider the impact of its citizens externally. So if we're using, and we in the Western world are using most of technology to the detriment of people that are outside, and that link is often missed. So when we want to think about the environment or employers or data workers, for example, then that is, of course, a difficulty in how to include that in the discussion. I do think that the right to data protection has some legal avenues to help. And the GDPR, for example, it allows for NGOs to bring cases. It has this very specific provision about allowing also groups to make cases. And there is still the question and issue, as you mentioned, when we're talking about groups that have nothing in common, it might be difficult to bring them together in a legal case. But in a context of employment, for example, when it might be, the targets might be more defined, I think cases can be made more easily. And I do believe here that civil society is playing a very big role in trying to do that and make the best use of the right to data protection, but also now with the AI Act, the very limited right to explanation, for example. And that is why I have a very small note on the book that if we're spending all that money on tech, then we also should spend funds on civil society, enabling that counter resistance or questioning at least. When it comes to enforceability, it's a very well known and discussed issue for law in general, for the GDPR, and I think for the AI Act as well. There are so many different authorities that will be playing a part. When it comes to high-risk systems, the providers themselves are going to self-check that they are or not a high-risk, that they are producing or not a high-risk system. So that already creates problems. And then there will be human rights bodies and market authorities that are also responsible, and that might make it also quite complex. And then again, it falls onto perhaps civil society to fill in the gaps where national authorities might be struggling to keep up. And oftentimes it will be data protection authorities that have to do this as well. I think finally, when it comes to the question of social groups, again, if we look at the constitutionalization of the right to data protection, there has been what could be described perhaps a paternalistic approach to data protection, which though on the other hand you can interpret it as not leaving it up to the individual, and then trying to take an approach that is proactively protective through not this individual consent little cookies, but perhaps trying to put some limitations through legislation. But then again, we go through the whole discussion of political will and enforcement. And in the world of digitization, how far can you go outside the EU? These are my first thoughts on this, but...
Do you want to comment on something?
Oh, yeah. Well, there's a couple of things, maybe.
Yeah.
Yeah?
Fast.
Fast. No, I think the point about the way in which the EU not considering externalities, it still views itself as the sort of the metropole in a lot of ways, right? And we have the data colonialism and these kind of imperialistic kind of frameworks in terms of data pipelines, who clicks and cleans all the data, like SAMA in Kenya and all these kinds of other data pipelines, right? This isn't these value chains are not considered, I think, in the full in the way that maybe we think of. Like value chains for sweatshops and that sort of thing. So that needs probably some research done, young PhDs. There's also in that there's an opportunity cost with focusing on build data centers instead of thinking where could we allocate resources to actually make society better rather than become sort of vassals for US tech capital, although digital sovereignty of the EU may provide some buffer there. We'll, turn up on May the 8th for that discussion. And then the question of enforcement, I mean, it always makes me think when we have these conversations about how the state should enforce this or that sort of thing. It always seems to me to leave out the institutional actors, you know, in terms of trade unions. Because if you think about who's actually on the ground, understands how a particular technology is being deployed or a particular employer is engaging in certain practices, it's usually workers, organized workers with a trade union backing that can ensure, you know, that proper procedures are being followed, and if they are not, raise a grievance and use the kind of legal infrastructure going on there. And I think there was a shift to that in health and safety law in the UK in the 70s, moving more towards that kind of cooperative trade unions role, I think, you know, in the context of other conflicts. But yeah, those are my thoughts. So.
Shall we gather some questions? And then if you want also to comment on this when you reply, of course. We can start with questions here. I also have some questions online if you're still shy, but I will first give you all the chance to ask some questions to Plixabra. I will gather 2 or 3 if that's okay with you.
Yeah.
Anyone? Yep.
I wondered...
Wait just a second. Yeah, just for the people online so that they can hear.
I wondered... whether there is a balance here between the right to be safe and the right that you're looking at in terms of the mass surveillance. That didn't come particularly, I haven't read your book, so I know particularly clearly in the discussion so far. That's one point. The second point is, which kind of leads to it, I wonder some of the risks would be mitigated if there were some fire breaks around what could be done and what couldn't be done. I'm just thinking in particular the risk of extending, you know, you look at terrorism and the other one is, the other extreme is petty theft. It's okay for terrorism, but not perhaps for petty theft. That kind of graduated control over what can be done.
Do we have other questions here? Yeah.
Thank you very much. I was just wondering, you mentioned you said something about the presumption of innocence when you're going through the different human rights that were impacted. So right to a fair trial and presumption of innocence. But you said that when you looked into it further, actually for people who haven't committed a crime or weren't going to commit crime, they weren't really protected under that right for some reason. Could you just go into that further? And also, I had another comment. Just around the difficulty of bringing legal challenges, because I guess by the very nature of predictive policing and mass surveillance tech, it's really difficult for individuals to understand whether they've been impacted or affected in some way. And where there have been cases in the UK that have been brought by individuals, often it's, as you say, with the backing of NGOs who've supported them to do subject access requests, etc. And so it's there's just this difficulty in actually being able to use the law in order to, I guess, safeguard rights or hold institutions using this technology to account. Just wondered if you could say anything about that as well. Thank you.
Do you want to start with these ones, which were 4?
Yeah. Thanks. A very small note on the previous comments you made, that I agree very much on all the research that should be done. The fact that when it comes to about where the resources should be allocated, that is also the main issue with predictive policing. It is put forth as a way to manage resources without actually looking at what causes crime. So that all fits into the same mentality of just throwing money to technology and this techno-solutionism. When it comes to the right to be safe and secure, I looked into it but didn't go through it in my presentation. Strictly speaking, from a jurisprudential perspective, the right to security is very limited. It's about when you're detained, then you should be secure. When you're losing your liberty, when you're going to jail, your life should still be protected. So when political actors raise this argument that we have to ensure protection of the right to security, that is not actually what it is at stake, legally speaking. So I looked a lot into how we could interpret this right and whether we can make a balancing between the right to security and the other rights. But in fact, most of my research came down to the fact that it is a factual argument. Yes, we need to be safe in order to enjoy all other rights, but that doesn't mean that there is a right that can be counterbalanced. So that's why I ultimately turned to the rest of these fundamental rights that I looked at. When it comes to the limitations or a gradual control, that is of course the hope that when something is implemented, it stays there and it doesn't get exponentially expanded. But we have seen often the reverse. So when I say, for example, it started as counterterrorism measures, but now in, for example, the air traveling measures, the PNR directive, it has a list of 16 serious crimes that are interpreted through national law. So this list can get very broad, even though it's supposed to be controlled. And then they want to put that measure not only on air traveling, but now also during train travel. So we see more political will towards expanding than restricting. When it comes to the presumption of innocence, so the thing with these rights is that they, especially for trial, it only starts from the moment there is a criminal charge. So you need a crime. And fair trial, you need a suspect. From the moment somebody is considered a suspect, then they start enjoying certain safeguards. But when we have profiles of potentially threatening individuals, it is not very clear what type of measures can be taken. I know more about their traveling example, where they might be subject to additional surveillance or controls, but that doesn't put them in the criminality part of the criminal justice system. They're still a pre-suspect or a profile, which is of course also very difficult to contest, but they are not considered as a suspect. And the courts have said that preventive measures or placing somebody under surveillance do not raise these safeguards. And when it comes to contestability, and of course that is why these rights are very important, because they are meant to ensure the contestability of evidence, for example, to be able, for the person that is subject to these measures, to be able to understand how this decision came to be. And that is why I argue, and there are several other authors that argue the same, that NGOs should be able, for example, to bring a case even before there is a victim. So when there is known that a system is being used and raises certain flags, that should be able to bring a case. So that is where perhaps the right to data protection could help.
Shall we go quickly for another round here? And then I know that we have the questions online. We will get to those ones as well. But quickly, yes. Maybe we start there and then we go to you.
I'm just wondering, looking from the other side, did you in your research come across how much benefit there would be if, they did use mass surveillance for, let's say, like policing, in terms of just allocating resources better? Because these systems do tend to be overburdened as well, right? So I assume that's a real motivation for why they want to do this to begin with. But sometimes, in my experience, they'll like kind of police AI before it's released, so then you don't know ever like how good it would have been. Yeah.
Thank you. A question about transparency in maybe 3 steps. The first is, and I assume the answer is no, is there somewhere that one could go to look at what are all currently the predictive, preventive? Okay, so the answer is no. Next step, would it make sense to have one? And who might institute that? And the next step, would people argue, well, that wouldn't help, because if it was very clear what was going on, people would change their patterns of behavior and then it sort of becomes redundant. Transparency is normally what we argue is the thing that makes things better.
Do we have any other question here? Maybe if you want, you can start with this ones and then we go for a round online.
Yeah, that's good. Thanks. When it comes to the benefits, so Matt very briefly mentioned that, for example, Professor Korf had done a research on the false positives of the PNR directive and calculated that even with a 99% accuracy rate, there would still be 500,000 people falsely accused of being a threat. And that is not, we're not even close to that 99.9% accuracy rate. The court accepted 5 out of 6 false positives as being okay. So the question is here, first of all, how do we assess the effectiveness of these measures? There's so much discussion about predictive policing being projecting the past towards the future, being a self-fulfilling prophecy, where you're just continuously feeding into the same people and profiles, then directing authorities towards specific actors or neighborhoods. So ultimately, how do we even begin to assess the criminality rates? So that's something I did try to look a lot into, and I think it requires a lot more expertise than mine, and sociologists and criminologists would have a much better opinion, I think, than me, but I could not. I think a lot of people raise a lot of questions as to how to assess this benefit. And now we don't have concrete evidence of what the results being quite good. When it comes to the transparency question, so the AI Act is meant to have a list of AI systems, but for security purposes, those have to be kept secret. So that is always the issue. Security enjoys a higher degree of secrecy, to an extent reasonably so, but when it comes to AI systems, simply saying that this authority uses a system, I'm not sure whether that would allow criminals to escape it, because the main problem is that we don't understand how these systems work in the first place, and likely a lot of these systems are repurposed from another commercial use. For example, predictive policing started through these heat maps where crime hotspots were based on environmental prediction, where an environmental disaster might hit, for example. So I think that the secrecy argument could be a little bit mitigated by having a more general list of which authorities use what types of systems. And I do think that ultimately through a freedom of information request, you can get some information. So there is a report, I think, for example, from, I think it's Algorithm Watch from a couple of years ago, that they have quite a broad list around Europe. But then we again rely on the NGOs to do that work.
So I will go maybe all or some. You tell me if there are too many or when there are too many of the questions that we have online. We have first a few concrete questions. There is one question that asking whether you have looked at the AML package of the EU. And then somehow related to that one, what is the reason that civil society organizations are not paying attention to AML CFT legislation creeping into society? And then, well, if you're okay, I will ask you two more. Mm-hmm. I will ask, all the questions will be asked at some point, but because you briefly mentioned the discussion about the list of what systems are being used and what companies and so on. There is a question about, for the EU context, what are the largest or most prominent private technological firms that feature most prominently in the pre-crime policing, and with the example of Palantir, and whether you have looked at that. So if you want, we can start with those ones, and then I ask you some more from the people online.
Yes, thank you. I looked only at the very specific obligations under the Anti-Money Laundering Directive when it comes to the processing of the personal data, to retain them and to make this analysis of suspicious transactions. because it's overall quite a beast, and there are people working in Tilburg very specifically on this. So I would suggest looking at those. Why they are not linked with the CFT legislation, perhaps, if I can make an educated guess, would be that the anti-money laundering package is an internal market instrument. It's meant to help the functioning of the market, while the CFT is a clearly counterterrorism measure. So that is, again, the issue of they're meant to have different legal bases, but in fact they're quite intermingled. I would not be able to tell you which are the most prominent tech companies, also because a lot of countries use different. I know that the Netherlands they have a lot of predictive policing, and they have been using for a while now. So you do have these bigger ones, but that might not mean that member states can still develop something in-house. And of course also like projects like Horizon Europe and H2020, they were funding such projects for a while now. So there has been also internally a lot of development of this tech.
So I will go to the other questions from the people online. There is a question about the statistics on the effectiveness of these pre-crime technologies that I think that you covered a bit when you were pointing to the other research. But then the same person asks, which communities do these technologies pose additional or disproportionate harms in practice? And I think that you mentioned a bit about it, but probably you can expand more on this. And then thinking specifically to migration and Eurodac, how is mass data surveillance and predictive policing coming into use, specifically when dealing with these issues? Are these anticipatory tools being used in an extraterritorial manner, for example?
Yes. So indeed, about the statistics, there are few, but so far there have not been any concrete numbers on providing quite for the effectiveness of these tools. Also, even on the standalone of both the effectiveness of the surveillance instruments and of the techniques as such. The communities are usually the ones that are traditionally, historically disadvantaged. I think we know that in a lot of predictive policing, if it's developed in the US, and when I started my research, we were mainly talking about the US, if the highest numbers of historical criminal records include primarily African Americans, for example, then those technologies will be directed towards those communities. When it comes to the section, the field of migration, we do see the same language in the AI Act with predictive policing and predictive profiling in the migration sector. They're also considered high-risk systems. I have not looked into it specifically, but I think this would be very similar technologies again, but this time the landscape is even more complex with whether migration fits under the security or border control, and the legal framework is even more fragmented.
I don't know if anyone has questions here in the room. I have two that I've been saving to give others the chance to ask you. We have one there. We go to you, and then I will ask my questions as well.
So, if you are like using predictive policy not to exactly forecast, but trying to see what that forecast is going to tell you, as you said, if you keep going back to the same data and data again, then obviously you're going to see crimes in that exact neighborhood and not somewhere else. Is there some kind of way to make this system independent of police records, or not on the past data that they have, but the new data that they're monitoring?
So I have two questions that perhaps will diverge a bit from the specific conversation, but I wanted to ask you one about the Trump administration, this Trump administration, and if you have looked at any changes in terms of their use of predictive policing, like mass surveillance for predictive policing and so on and so forth. I would expect more use, more open use, and so on and so forth. And I wanted, to pick your brain on that. And also, you mentioned that now you're working on digital sovereignty, and I wanted to ask you about the connection, whether it's a completely different project or whether you're also building on insights from this project, and what are the key questions or the lenses that you're considering for the analysis of digital sovereignty from a legal perspective.
Great. Okay, so starting with the forecast, I would not suggest making the system independent, but that is the reason why it now moves into this private company data. So when you collect all the information on where we travel to and for what reason or which flights we're taking, these are not past criminal data. The idea of the PNR directive, for example, is that this data should allow for new criteria to be developed. But then we go into the realm that is the same for all algorithmic profiling. How are these decisions made? Why are certain groups of people clustered together? And ultimately, the system aims at identifying correlations, patterns that repeat themselves, rather than causation. So in the field of criminality, again, that remains an important factor. When it comes to the Trump administration, I think every safeguard is eroded at this point. If we look at all the students that are being captured, all the federal government that is being completely falling apart, I think that there are no breaks to the surveillance taking place right now. So I'm afraid that it's happening entirely evidently now, and without any breaks. When it comes to digital sovereignty, it started as something that was entirely new. I wanted to move to something new after having spent quite some time on this big project. But I still find several connections when we talk about the political will of the EU. We often see when the EU is talking about digital sovereignty, this idea of promoting our values, of being the global norm setter. And that raises, I think, a lot of questions of what are these values that we're promoting? How are we doing it in a way that we consider the externalities, but we are not doing it in an imperialist manner, given that sovereignty carries a lot of that legacy. So my research project is also linked to another set of very weird technologies, being quantum technologies. So I'm looking into the governance of quantum, and I look into how digital sovereignty is pushed forward through also paying a lot of attention of new technologies, and quantum again are promoted as quite the game changer. So I want to look to what extent there is a sense of, again, techno-solutionism that is being promoted. Are there more realistic ambitions behind it? And how is this relationship being constructed? It's less about law, and it's perhaps a bit more, about the policies around this. And again, here, I think the private actor has a big role to play, because all these technologies we're relying, or we need private actors to be involved and spend money to be able to keep up with the US and China, or that is the lingo used. So I look very much forward to your discussion next month.
Okay, everyone, if we don't have any further questions, I forgot to ask also on the Zoom, but I assume that you don't have any further questions. So I think that we can finish the talk thanking you a lot for this brilliant presentation, inviting everyone to read and buy the book. and join us also upstairs for just continuing the conversation and a drink all together. Thank you.
Thank you.